Good evening, everyone. On behalf of training leader in the field of IBC transition, I welcome all the participants to the very significant webinar on a burning topic, imposition of penalties by IPAs on IPs. Today, we have with us Mr. Ashish Makhija, well-known personality in the domain of IBC from New Delhi, and Mr. Snehal Kamdar from Mumbai. I extend a warm welcome to all of them. I also welcome Mr. Pratim Dayal from Kolkata, who will moderate the entire discussion. Before I hand over the proceedings to Mr. Pratim Dayal, let me briefly introduce Transition to you. Transition is an undisputed leader in the field of education and training in IBC domain. It has grown from a startup to a well-known name amongst insolvency professionals and those practicing in IBC. Transition is known for conducting excellent knowledge sharing programs for IPs, and its master classes are much sought after. Shortly, we will announce another masterclass, so please keep watching our website transition.com and social media pages Facebook and LinkedIn. Our Transition Alumni WhatsApp group is one of the best in knowledge and discussion in IBC matters. Our Sure Shot IP program has benefited number of candidates who owe their success in limited insolvency examination to the focused approach, and the classes are taken by none other than IBC Guru Mr. Ashish Makhija. We are fortunate that he is associated with us in our journey of knowledge dissemination. Now, I would request Mr. Pratim Dayal to take over. Over to you, sir.
Thanks, Neha. Thanks for the brief starting. Today, we are definitely very excited to have this session, and we expect a very good participation. First, I will invite Mr. Parag Singhal, who is an insolvency professional also, to introduce to the audience our speakers on these subjects today. Mr. Singhal, you can introduce all the speakers.
Thank you, Mr. Bayal. Friends, as we all know that we have three speakers today, Mr. Ashish Makhija, Dr. Gopal Krishna Raju, and Mr. Snehal Kamdar. To begin with, let me introduce Mr. Ashish Makhija to you, although I believe he needs no introduction. He is a respected professional in the field of insolvency and bankruptcy court, and many of us, including me, to a great extent owe our success to his immense knowledge which is shared passionately by him. I haven't come across any speaker as of now who explained the complicated provisions of IBC in such a simplified manner. I strongly believe that Mr. Makhija has a solution to every problem in IBC. For the unintended, he is a leading practitioner in IBC, having number of groundbreaking judgments, orders to his credit. Have you ever heard of 2 resolution plans being approved in a single case? He has made that possible. He'll share. He may like to share it in his deliberation. His legal opinions are always to the point with extreme clarity. He is an established author, a well-known speaker, and a wonderful human being. We are very lucky to have him with us today. Welcome, Ashish ji. Friends, we have among us our second speaker, Dr. Gopal Krishna Raju, fondly called as GKR. CA Dr. Gopal Krishna Raju is a practicing chartered accountant, company secretary, ICWA, PGDM, insolvency professional, and a registered valuer. He is from Chennai. GKR has been awarded honorary doctorate in governance of GST in government sector by St. Mother Teresa University, Melbourne, Australia. He is an author, passionate writer, speaker, and an active Rotarian. And Ashish Makhija ji also a Rotarian. I am also a Rotarian. So he is nominated on the governing board of various government and non-government institutions, councils, and colleges. I, on behalf of all the attendees, welcome Dr. Gopal Krishna Raju. Last but not the least, we all have heard his name, Mr. Snehal Kamdar. CA Snehal Kamdar is a leader with grounded roots, He has worked consistently for the benefit of IPs and insolvency profession in general. He is a managing trustee of IP Foundation, a charitable trust formed for creating awareness on Insolvency and Bankruptcy Code 2016. He is actively involved in the events of ICI and has been a part of few committees on IBC. I welcome you all on behalf of Transition. Ritamji.
Thanks, Paragji, for this nice introduction. And everyone will be eager to listen them and take their perspective. So you will go to the session. Before that, I would like to convey some basic principles that we will follow so that we can make this webinar on the very important subject very much communicative, so that everyone can get to know what is being communicated in a coordinated and organized manner. So I would request all the participants be visually present, but to start with, they should be muted so that we can avoid unnecessary noise and everything. Because attention will be very much a required thing for this webinar to be make successful. So please, participants, do not make yourself unmute. Just try to listen to the sessions. We will have a question answer towards the end. At that point, we can have the question answer that also in an organized way. And whoever wants to raise any questions, they can write in the chat box. That will definitely help us to coordinate the program in a right manner and in an intended manner, and help the speakers present their views in a thorough manner and in a very more communicable way. And they can, if anyone wants to say something or something, they can raise hands. I think raise hand option is there. That will be more a better way to participate. So that is the basic principles that we will follow today, and we'll try to make this interaction more communicable, more beneficial to all the attendees today, and we'll make and we'll try to achieve what we intend to say today. So with this, I would request Ashish sir, so this will be our basic principles, and our flow of program will be like that. Ashish sir will first introduce to he will give a presentation on the circular itself, on the matter. Then Dr. Raju will give his first reactions on the how it is impacted on the IP profession as well and the professionals. So this will be his thought out, and after that, Mr. Snehal Kamdar, CS Snehal Kamdar will give a perspective on the quantum of penalties. So this is our more or less, and then we will conclude on the presentation side with Ashish sir's input on the legal tenability of the circular. So this will be the flow of our presentation today. And after that, we will go to the question answer session. So with this, I would request Ashish sir to share his presentation, and everyone is eagerly waiting for that. Let us, sir, you start your presentation.
Okay. First of all, a very good evening to all the participants. Friends, this is a Sunday, and with such large number participating on a Sunday evening, well, it speaks of the volumes of the circular, the impact of the importance of that circular, how it's going to affect the IP profession. And I must thank Transition for holding this webinar in a very, very timely manner. In fact, this circular has come in only on 27 July, and they have been the first one to organize this kind of a webinar. What we believe, friends, may I request everyone to please mute themselves? Yeah. So, in fact, I don't know whether IBBI is going to hold this kind of a webinar or not. I don't know whether any IPA will hold this webinar or not, right? Because probably they will be little, afraid of that this kind of a thing can be done or not. Anyhow, friends, let's not get into that detail. First of all, let's understand the impact, the circular itself. I'm not going to speak against or not going to speak in favor at this moment. I'm only going to present what the factual position is. So let's understand the factual position, and then we are going to debate amongst ourselves the impact, the effect, and whether it is a right circular or it's a wrong circular. All those kinds of things will be discussed in a very, very candid manner. So let's presume that. And our friend Mr. Snail Kamdar is there. He's gonna take all the notes today, and he's gonna make a representation on your behalf. So I think this is one of the things which are going to happen. So let me share my presentation with you. I'll just start with that. Okay, so friends, this circular, uh, well, this is the picture. I believe it speaks more than 1,000 words, isn't it? So somebody is pressurizing and trying to take out the money, you see, out of the other person. Okay, and that poor chap is nothing but the insolvency professional. So friends, let us look at the circular. This circular was issued by IBBI on 28th July. Well, friends, this is not the circular which has you see been issued, but you will remember that on 22nd July 2021, the model bylaws and the governing body regulations of IBBI, that means for IPAs, they were also amended. I don't know whether anyone noticed or not. They actually sneaked in one and they amended one or two provisions in that. So I'll take you to that also. In fact, this is a consequential circular based on that amendment later on. So let's also see that it has been done in a coordinated manner. It is not something which has jumped on 28th July. It is the effect of 22nd July amendment which they made. Okay, monetary penalties to be imposed by an IPA. Well, friends, what is the genesis of this circular? Let's try to look at the genesis of the circular. The genesis of the circular remains is the clause number 24(2)D of the schedule. Everyone will recall that there is a schedule which is attached to IBBI model bylaws and governing board of IPA regulations. There is a schedule which is attached to it, and in that schedule, model bylaws are given. So every IPA, wherever we are registered, they have got their own bylaws based on model bylaws. So model bylaws is applicable to all IPAs. So if you are a member of any IPA, well, definitely that bylaws are also applicable to you. There is a particular clause 24. Now that I'll come to that 24, 25. These are very important clauses are there. I don't know how many of us read it or not, but definitely we're going to touch upon the relevant portions today. Model bylaws of an insolvency professional agency. This is exactly what it says. Okay, friends, I request everyone to, I think I request organizers to mute Can you please mute everyone? Okay, thank you. I think, friends, if we remain muted, then I think we'll be going in a better manner. So clause number 24, my dear friends, of the model bylaws, it talks about disciplinary proceedings. So please underline disciplinary proceedings. And 24 clause, subclause 2, it says the orders that may be passed by the disciplinary committee. Here we are talking about the disciplinary committee of IPA. We are not talking about the disciplinary committee of IBBI, because IBBI's disciplinary committee is as per section, as per the statute, as per the code. It is not formed under the IPA model bylaws. So 24(2) says the orders that can be passed, and it says it shall include, and D clause says imposition of monetary penalty. So it was already there. It's not a new clause. It has not been amended. But this circular is now impacting this particular monetary penalty. Right now, if you ask me a question, that if any disciplinary proceedings are going on in an IPA against an IP, well, then disciplinary committee of IPA, it had got all the powers to impose monetary penalty without any limit. There was no limit which was prescribed so far. What this circular also attempts to do is basically it wants to standardize the fixation of the monetary penalties. So let's look at it in that manner also. Now, I'll go one clause earlier, which says the agency may initiate disciplinary proceedings by issuing a show cause against professional members. So IPAs can also initiate disciplinary proceedings, but one thing which they need to do is, and please underline this word, show cause notice. Because the fixation of monetary penalty is one of their powers which they can, supposing an IP is found guilty of the disciplinary proceedings, I mean of a professional misconduct, then they can impose monetary penalty. But prior to that, prior to starting the disciplinary proceedings, initiation can be done only by issuing a show cause notice. So no monetary penalty can be fixed by an IPA without a show cause notice being issued to an IP. So this is one of the important things. Now, what is the basis of initiation? Now, basis of initiation can be four type of things based on a reference made by grievance redressal committee. We all know that there is a grievance redressal committee also of all IPS in each IPA. Supposing somebody has filed a grievance based on some document, looking at the documents, if the IPA finds or the grievance redressal committee finds that, look, we need to have a disciplinary proceeding, we must initiate a disciplinary proceeding in this case, well, they will write to the disciplinary committee and the disciplinary proceedings will be initiated. Number two, based on monitoring of the professional members. Now, there is another committee which is also there in IPS, which is known as monitoring committee. Now, that monitoring committee can also, write to the main governing body, and governing body based on the the recommendations of the monitoring committee, they can also say, let us initiate discipline proceedings. Third, following the directions given by the board or any court of law, like adjudicating authority, if it says initiate discipline proceedings, or high court or supreme court, well, they have no option but to do it. Similarly, if the board or the IBBI tells them to start initiate the discipline proceedings, IPAs have to do it. And fourth is extremely important, it says suo motu, and it is based on information received by it. Somebody files an information that something is wrong in this process, like CIRP or liquidation or something like that, well, it could be initiated on suo motu basis also. So based on the information which is received, of course, the information must be cogent, information must be proper, and it should not be anonymous, because their internal circular also says anonymous complaints or anonymous information will not be taken into consideration. So this is extremely important, friends. We must really understand this. Now, this is also a genesis. What is a genesis? If we go back and see Bankruptcy Law Reforms Committee report, and in fact, this line has also been repeated in circular. It says IP agencies will have the flexibility to impose a graduated system of penalties, where minor non-compliances will result in monetary fines and major violations will result in expulsion from the agency. Now, there are two things which are very important, friends. BLRC also said that, look, if somebody does a bad job, somebody does not do, compliances, there could be two types of non-compliances could be there. Minor non-compliances, and then there will be major non-compliances. If there are major violations, well, it could result in the expulsion of the person. I mean, you will not no longer remain a member of the IPA. Or there will be, if there are minor non-compliances, well, in such cases, there will be some graduated system of penalties. That means for this particular offense, it should be this, for this offense, it could be this. So they said graduated system of penalty. So this was only a recommendation, right? So that recommendation, well, let me ask you a question. Which one is better? Monetary penalty or expulsion? Because many people, come to me when their disciplinary matters are going on before IPBI, because I am also taking up such matters. Well, sometimes they tell me, he says, if they can impose a penalty of 3 lakh, 4 lakh, get it done with it. I don't want expulsion. I don't want that I should be deregistered. So sometimes monetary penalty is better than the expulsion. So that is also one of the important things. Okay. So penalty or expulsion, that is also one of the choices which are there. Friends, we must understand. There may be, another perspective that this circular is draconian. This circular is absolutely closing down the business of the IPs. It is discouraging IPs. No quarrel to that. Absolutely no quarrel. But let us also understand the other perspective also. Are we not going to discipline people who are not following the law? That is also one part of thing which is there. Of course, things have to be in a better manner, and how they should be drafted, that's a separate issue. We will just talk about that. But why this circular? Now, look at this. This circular is an advisory to the IPAs to amend their bylaws and to provide for maximum or minimum penalty for the non-compliance. So friends, they have not amended they have not, you see, amended the bylaws of IPS. It is now left to the discretion of the IPAs that they will have to amend it. So this circular, in fact, has not come into effect. This circular will be effective only once the IPAs amend their bylaws, and only then it will start operating. So let us understand this. So once and only, and secondly, it will be applicable where the disciplinary action gets started. That means the show cause notice has been issued and the person is found guilty, and then the monetary penalty can be imposed on the professional member. So it's a long drawn process. It's not that every IP is going to be under this particular penalty from day one itself. Of course, there is a responsibility factor which is related to this. And the chart, the IBBI says, or the circular says so, that it has been provided to ensure objectivity and uniformity. Well, they wanted that, look, maybe on a particular aspect, on a particular non-compliance, one IPA imposes a penalty of 5 lakhs, another imposes a penalty of 50,000, another does not impose any penalty. So the IBBI wants that there should be absolute uniformity, there should be consistency, and there should be objectivity. So therefore, they have defined some kind of non-compliances, in fact, 14 in all, so that uniformity. And they have also come out with a chart of uniform kind of penalty which is there. This is what exactly is there. I've just noted down in all my 14 slides. So let us try to understand. Number one, it says, if the IPA fails to submit disclosures, returns, etc. to IPAs, or submits inadequate or incorrect disclosures, returns, etc., relating to any assignment required under the code, regulations, or so and so, so and so. Now, here it is a complete question is failure to submit or incorrect disclosures which are being made. So both the portions are covered. So like one IP does not file it, or somebody files this, but they are inadequate or they are incorrect disclosures are there. Obviously, it's a fact-finding exercise. If you don't submit it, obviously one needs to be penalized. Now here they say up to rupees 1 lakh rupees, up to rupees 1 lakh. So it is basically up to rupees 1 lakh or 25% of the fee, whichever is higher, subject to a minimum of 50,000 rupees. So they are saying that minimum is 50,000 and maximum could be a higher of 1 lakh rupees or 25% of the fee. Now, one question which can arise is what is the meaning of the fee? We'll just have a discussion, but first let's understand what is there in the circular. We're going to discuss all these debate, all these things. Number two, accepts an assignment having conflict of interest with the stakeholders, because the conflict check is to be done in the first stage itself. So there should not be any conflict. And well, if you don't have conflict, you are not covered under this, isn't it? So again, here the penalty is minimum 1 lakh. And so again, here the penalty is minimum 1 lakh and maximum going up to either 2 lakh rupees or 25% of the fee, whichever is higher. Now, one interesting question which comes is, let's look at the few of the penalties and then I'll come to that. Fails to maintain records properly relating to any of his assignment. Now, the meaning of the word properly, I think it's very confusing. I mean, it's not objective, it is subjective, isn't it? So one needs to really look at this. What do you mean by proper records? And then, of course, minimum penalty is 50,000 going up to 1 lakh or 25% of the fee, whichever is higher. So that's the standard one, but somewhere it is 1 lakh rupees, somewhere it is 2 lakh rupees, but other thing is absolutely standard, maximum 25% of the fee. Rejects a claim without giving any proper reason. Now, what do you mean by proper reason? Supposing I've given 5 reasons. You don't find those as proper? I mean, it should be without giving any reason. If I am giving a reason, it may be proper or improper. It is a judicial authority. NCLT has to go into that. Anyhow, while undertaking an assignment or fails to exercise due diligence in claim verification. Now, due diligence again is a very, very subjective criteria, friends. And now we have read, you see, first 4 penalties. Look at this. The maximum could be 25% for each kind of non-compliance. Now tell me, if somebody is held guilty for first 4 itself, now will he be liable to pay 100% of the fees because 25% for each, isn't it? And supposing he is held guilty for 6 non-compliances, so is he going to be penalized up to 150% of his total fees? Well, that is not clear. And of course, that is also not logical. But anyway, we'll definitely debate about that. Fails to comply with the directions issued by adjudicating authorities. Well, if these failing to comply, let adjudicating authority take a call. So why the IPAs are getting into it? Anyhow, so still it says that minimum 1 lakh and maximum 2 lakhs or 25% of the fees. So these are 14 types of penalties which are there. Outsources duties and obligations. Of course, an IP cannot outsource its duties and obligations to anyone, but if it does, then these are the penalties: minimum 1 lakh, maximum 2 lakhs. Fails to appoint registered valuers wherever required under the code or regulations made thereunder for conducting valuation. So friends, this is another area which has been actually IBBI has been looking at very deeply on the registered valuers, appointment of registered valuers. So this needs to be done. So minimum 1 lakh, maximum 2 lakhs. Fails to supply the information called for or to comply with the requirements of information sought by IPA, board, adjudicating authority, or appellate tribunal, or does not cooperate. Wow, this is too huge. It covers the entire gamut. And again, minimum 50,000, maximum 1 lakh rupees. Fails to make public announcement in the manner provided for in the relevant regulations. Again, minimum 1 lakh, maximum 2 lakhs. On the one hand, when we make public announcement as IPs, we pay from our own pocket. And now this is also one of the fails to provide notice regarding meeting of creditors. So 50,000 minimum, maximum 1 lakh or 25%. Fails to reject resolution plan from ineligible resolution applicant. Well, I don't understand what is the meaning of this. Who is IP to reject a resolution plan? He is simply asked to prepare a report on all the resolution plans received. Well, do you remember the Supreme Court judgments on this? They were very clear on this particular aspect. 25(2)J read with section 30. Now, you see there was a clash between the two sections. One section says that all the resolution plans received have to be put up before the committee of creditors. And the second section, section 30, says that only such resolution plans which comply with the provisions of section 32 should be put up before the COC. But the Supreme Court said that no, it is the duty of the IPs or the resolution professional to place all the resolution plans, whether they are in compliance or not. So it is his duty to just submit those plans along with his report. Now he is no one to get the rejection or acceptance of the plan. How can he influence the committee of creditors? I don't know. I think this is something which is really, I believe that this is not a correct way of looking at the things. Fails to take action in respect of preferential, undervalued, fraudulent, or extortionate transactions. Now, fails to take action means, I believe, formation of opinion, determination, and filing. I think three things could be there, right? So opinion is to be found within 75 days, determination to be done in 115 days, and filing of the application to be done in 135 days. Probably, I think they're talking about that. But again, this is not clear. Enters into contract or agreement with professionals in an incomplete and an improper manner. Who is going to decide? Which is what is incomplete and what is improper? I can have a half-page engagement letter. I can have one-page engagement letter. I can have three-page engagement letter. So it will be better if the IPAs can give us the engagement letters for all the professionals so that the contract or agreement is considered as complete and improper. Well, this is something, again, very, very subjective, my dear friends. Fourth is contravenes any provisions of the bylaws or regulations for which no specific penalty has been provided. Again, 50,000, maximum 1 lakh. So friends, this is the overall gambit, 14 clauses which have been put in, which are, some of them are definitely controversial. Well, let's look at this. This is another important aspect. What is the mandate by the IBBI? IBBI says that all the IPAs shall amend their bylaws and they will incorporate clause number 24, subclause 5 also. So first they have to incorporate that particular imposition of monetary penalty chart, number one. Number two, they have also said that please amend clause number 24, subsection 5. And look at this. The model bylaws regulations, they were amended on 22nd July 2021 by IBBI. They did that in their regulations. And of course, those model bylaws have to be adopted by IPA. So they are now saying, you also amend your bylaws, whatever you have adopted. Now look at this. What is the meaning of 24.5? 24.5, which was amended on 22nd July, it says the agency shall promptly realize the monetary penalty imposed by the disciplinary committee and credit the same to the fund constituted under section 222 of the code. Very interesting. So they say that the IPAs, whatever monetary penalty is imposed, now they should realize it very quickly, and then they will not, use that money. It is not for the benefit of the IPAs. They will deposit in the fund which is constituted under section 222 of the code. My friends will recall that there are two types of funds under IBC, 222 and 224. What is the difference between 222 fund and 224 fund? Let me take you to the next slide, and then I'll come back to the difference on this particular aspect. The unamended version prior to that, because 24.5 clause was amended. Let us look at what was the previous clause. It said monetary penalty received by the agency under the orders of the DC. Friends, can you please mute?
No.
May I request organizers to please mute everyone? Thank you. Monetary penalty received by the agency under the orders of the DC shall be credited to the insolvency and bankruptcy fund constituted under section 224. Are you looking at what are the two changes they have made? Number one, they have to collect promptly. This word was missing. Two, earlier, the money was to go in insolvency and bankruptcy fund, which is created under 224 and not under 222. Now they say that you will credit it 222. Now, what is the difference between 222 and 224 fund, friends? I think those who have attended short classes with me, I think they are aware of that. 222 fund is an internal fund of IBBI, which they can use for payment of their own salaries or the payments to the chairperson or the members and so on, and to their employees also. Because government wants IBBI to be autonomous body. So generate your own revenue to meet your own expenses, including the salaries of these chairperson and whole-time members and the employees also. So now they want that the penalty which is being imposed, it comes to the internal fund of IBBI. 224, my dear friends, is an external fund. External fund, you know that there will be some grant or contributions, or even anyone can contribute, and supposing any company contributes and tomorrow it comes into insolvency, then it can draw those funds. Out of those funds, it can draw the money, whatever it has been deposited. So that is kind of an external fund. So earlier it was planned that it will be deposited in 224 fund, but now they have changed it to that it should be deposited into internal fund. Okay. So let's look at one more aspect which is there. Power to issue circular. Now the big question is from which section they are getting a power to get this circular issued. Number one, it is mentioned in the circular that they are issuing it under section 196. Let's look at 196 carefully. Few clauses. Subsection 1, clause number AA says, promote the development of and regulate the working and practices of IPs, IPAs, and information utilities and institutions and other institutions in furtherance of the purposes of this code. So they say they can regulate IPs and IPAs. So probably this is a step, you see, towards the regulation of IPAs. Number two, I don't know whether it is covered under clause number C or not, but because it simply says levy fees or other charges for carrying out the purposes of this code, including fee for registration and renewal of insolvents, IPAs, IPs, and information utilities. So here the word is levy fees and other charges. Now, whether other charges will cover monetary penalty or not, I'm not too sure about it. Third, issue necessary guidelines to IPAs, IPs, and information utilities. 196 1P. Issue necessary guidelines. So this circular is nothing but a guideline, right? But this is a mandatory mandate. In fact, that is what it has been mentioned. Sir, please mute yourself. I think, may I request everyone? Okay, so 196 subsection 2. Thank you. So 196 subsection 2 says the board may make model bylaws to be adopted by the IPS which may provide for. Obviously, they have created that bylaws, regulations, and that has been adopted. The grounds on which penalties may be levied upon the members of the IPS and manner thereof. So grounds and the manner of levying the penalty. Quantum of penalty, it is not covered under this. Look at the next one. The quantum of fee and the manner of collecting fee for inducting persons as his members. So it is not even covered under this. The manner of conducting disciplinary proceedings against its members and imposing penalties. So again, it says the manner of imposing penalties. Well, whether the manner of imposing penalties will also cover the determination of the amount, giving them a mandate that you should fix the penalties like this. And lastly, the manner of utilizing the amount received as penalty imposed against any insolvency profession. So utilization, earlier it was being mandated that it will be used for depositing in 224 fund, but now they say instead of 224 fund, it should be deposited into 222 fund, which is an internal fund of the IBBI. So these are the provisions which I wanted to share with you. Now, what is the role of IPS? They have to mandatorily amend model bylaws because there is a dictum from IBBI, and IBBI is their regulator, IBBI is their boss. Now, the big question is, do they have a choice not to amend? Well, ordinarily speaking, I don't want to be in a position of an MD of the IPA because I will not be able to say no to IBBI. So ordinarily, I would say no, but if they can always take a bold decision and say, we're not amending it. Anyhow, I don't know whether they can take such kind of a stand or not. Now, unless amended, now this is one big question. Till the time they amend it, these monetary penalties cannot be effective. So first they have to amend their own bylaws. If they do so, and if a show cause notice is issued, if the disciplinary proceedings are initiated, if the person is held guilty, and then they decide to impose monetary penalty, only then a monetary penalty will be decided. So there are 4-5 ifs in between, friends. So it's not that straight away every IP is going to be penalized. It is only these steps which have to be followed. Only then these are the portions which will be there. So I'm just stopping it here on these two questions. Two questions are there. Of course, I leave it to Pratim also to ask these questions. Whether these panel monetary penalties will be prospective or retrospective, and whether these are civil penalties or in civil in nature or criminal in nature. So I'm just leaving it at there. I've got 2-3 more slides, but I think I'll cover it when this time arises. So I'm just leaving it at and handing over to Pratim. Pratim, over to you.
Okay, thank you, sir. Thanks for this wonderful presentation as usual, and getting insight into the circular and the genesis, especially important, how it will come and in what way it will be affecting the lives of IPs. Thank you, sir. Thanks for this. Now, I will request Dr. Raju to give his view as a reaction, the first-hand impression of the circular on the IPs, how it is going to affect the IP profession, and what is his reaction on the first-hand reaction. So, Dr. Raju, I would like to invite your comments on that.
Yeah. Thank you, Mr. Pratim. Mr. Ashish Makhija, Mr. Snehal Kamdar, and we have hundreds of very experienced insolvency professionals across length and breadth of the country. So my evening wishes to each and every one of you. Sunday evening, if we are able to assemble hundreds of insolvency professionals at this point of time, that shows the seriousness and an emergent situation with respect to this particular topic. Today, this circular, as Ashish Bhai has mentioned, I will also play a role of a professional, bringing before you the challenges of this particular circular. And it will be ideal for us to voice together before the board how far this has to be brought in practice. There are various challenges. By looking at the number especially a minimum and maximum penalty. It looks like IPA will be a shadow partner, 25% shadow partner in the assignments. But nevertheless, let us look the larger perspective. Always every issue will have the two sides to be understood. One side, this is one profession where if at all, the 3,742 as of yesterday, 31st July 2021, minus 3,742, they are the fulcrum of this entire profession. It will be very difficult. The entire ecosystem, name it IBBI, name it the IU or IPS, or even the adjudicating authority, the fulcrum of this entire ecosystem is the insolvency professionals. And predominantly, 54% of the insolvency professionals are from one single IPA. Out of the Tridev, I'll call them as Tridev, all the three IPAs. So the largest base is with the ICA IPA, triple IPA ICA. They are the 54% base are that means chartered accountants constitute maximum, and company secretaries constitute 18%, and cost accountants constitute 5%. The remainder are from bar council and the managerial experience. Now, point to be noted, I'll only bring before you, I will not repeat what Ashish Bhai has mentioned. I'll only bring before you suggestions or in the form of a voluntary mechanism which IPAs have to take a role. I believe, and I'm sure all the IPs also will agree with me, that IPAs are tier 2 regulator. They are not insolvency professionals, insolvency professional entity. Of course, being a tier 2 regulator, they are also equivalent to a regulator. This particular circular has been focused to direct IPS, I repeat the word, direct insolvency professional agencies, because the word shall has been mentioned. So they have to definitely amend their bylaws. And even in our examination, we would have got one very popular question. So what is the minimum days and how many days they have to print their bylaws and then send and all. So that stuff will definitely happen. But the challenge, first challenge which I want to bring before all of you is, we have the first schedule, and all the panelists, we are all members of ICA also, and I am a member with all the three professional bodies. And please understand, in all the three acts, the Chartered Accountants Act 1949, the Company Secretaries Act 1980, and the Cost Works Accountants Act 1959, the first schedule, part 4 and para 2, very clearly mentions this particular point, that a member of the institute, whether in practice or not, shall be deemed to be of guilty of other misconduct if, in the opinion of the council, brings disrepute to the profession or the institute as a result of his action, whether or not related to his professional work. This is very a significant point I want to bring. So suo moto, a DC can also be taken. So I will also be penalized here, and minimum or maximum, let us not go for that. And I will vouch the points that has been brought out by Ashish Bhai, especially the 196(1)(c), the powers and functions of the board, where it very clearly mentions levy, fee or other charges, where penalty has not been mentioned. Second, the 196(1)(g), which says monitor the performance of the IPA and IPs. Good. Monitor, and how it has to be done, that is where I'll give my suggestion. And the grounds, that is 196(2), which says the grounds on which penalty may be levied. Very rightly pointed out that quantum is not mentioned. And whether quantum has to be mentioned, my view is, let it be because wisdom of the IPS, let them take a call. That is my individual opinion. There may be a difference of opinion. There may be difference. I will also be ready for the various pointers here. Now, I'll just go with, I have very limited time to share. Point number one, we are first generation insolvency professional. I repeat, we are all first generation insolvency professional. Majority of us, we are chartered accountants, cost accountants, or company secretaries. We understand the Gurukul system. I repeat, we understand the Gurukul system. We have all been trained under a senior professionals. And we understand through that process, the documentation, through that process, the various agreements or various document procedures, filing, the presentation, all this we have been groomed. And being first generation insolvency professionals, giving us a lateral entry. I repeat the word, a lateral entry. The law by default believes us that we, with 10 years of experience, we will, by our experience, we have the capacity and capability. Recently only, all the three IPAs, the Tridev, have come together in coming out with SOPs. I repeat, that's a very good practice. And the law was born, I repeat, on 2016. Insolvency Bankruptcy Code is 2016. We are in 2021. So we are almost on the 5th year celebration. Almost 5 years we have celebrated, because by May 2016 itself it has come. Now only, slowly, all the three IPAs, Tridev, they have come together in giving, in coming out with statement of best practices. The role of insolvency professional, avoidance proceedings. Recently they have brought. I will appreciate this. Very good. Now, yahan 14 point. It is like, I am reminded of Ramayan Manav. Vanvas, 14 years of Vanvas. It looks like that. This particular circular looks like the 14-year Vanvas. And number one, there should be a proper training mechanism, strengthening our procedures with respect to following the IP practice. Second suggestion, what I want to give here, maybe if all these things are strengthened, maybe there will be a reason for bringing out a quantification. I always go by the the quality should be there with respect to the process of disciplinary, but not neither ICAI nor ICSI nor ICMAI. All the three professional bodies are standing institution for so many years under the Ministry of Corporate Affairs. There also we don't have. The penalty mechanism is there. That is, it is also not that, but it is taken at the discretion based on the quantum. Because rightly pointed out by Ashish Bhai here that it is not objective, it is subjective. Very good. So therefore, these are all professional challenges where it can only be subject. You can't quantify it. By quantifying it, it is like, okay, so why not we add this 50,000 or 1 lakh, or we will mark up 25% of the fees towards this. So all these kind of kachara, the thought process will always come inside. The point is, we need to have a very effective training system. Second, peer review system. Peer review system has to come. That will actually guide us, not in the form of finding fault, but in the form of guiding, in the form of hand-holding. Second. Third, very rightly, that particular point has been brought out, especially with respect to the agreements. I repeat the word, with respect to entering into contract or agreement with professional in an incomplete or improper manner. Today, tell me, I'm sure everybody will wholeheartedly touch your heart and tell, we have Google Bhagavan before us. Whenever we want an agreement to draft, either we will take our old file, or today even a better model is available at the helm of Google Bhagavan. So this particular, whether it is incomplete and improper manner, is something which is only a process. And maybe if codified process has to be brought out, like the statement of best practices that has been brought out for avoidance proceeding. I think a first step has been taken. Good step. That is with respect to point number 12. Failed to take action in respect to PFE. read the provision, you only have 75 days, form an opinion. How to form an opinion? Within 115 days, determine. How to determine whether mandatorily we have to go for a transaction audit or not? No, I didn't go for a transaction audit. What to do? So all this, now only an SOP is available. Similarly, in every place, all these 14 one was criteria, we must have some codified, not necessary code or regulation. That this codification, best practice has to be jointly brought out by all the three IPAs. When IPAs have the power to penalize us, okay, I will only use the word called regulators, not penalizers. It is also equally responsible. They also guide us, handhold us by coming out with an equivalent statement of best practices. I will also
Dr. Raju, the timing, I think your timing is
I'll just take one more minute. Last 1 minute. Last 1 minute. Now, with respect to the points that has been shared, I'll make only one more one more point that maybe I'll reserve my other few more comments while we are coming for the Q&A section. Sure. Thank you very much. Thank you very much for the opportunities. And this is, I appreciate transition as well as the other team members for bringing out such a, bringing all of us together and to share the thought process, germinating that this particular action by Insolvency Bankruptcy Board of India, where I think one thing I must appreciate IBBI, unless we are all been voicing individually. Today, it is a day to celebrate, is a friendship day, and IPs have come together. IPs have come together, and together we are giving a voice. Together we are giving a voice. That is actually a great a change or a development that has been brought out inside us. So the togetherness, the friendship among us, we have not spoken so far, maybe, but individually we have been doing our work. But today is a day we are showing our the strength as a together. Thank you very much.
Yeah, thanks, Dr. Raju, for your beautiful presentation. Actually, I was also listening very aptly the way you were interpreting different steps and insights and the steps that IBBI has taken and the position of IPAs and IBBIs. A very, very nice presentation, and I think the audience also liked it. Now, going to the next thing, I would request CA Mr. Snehal Kamdar to comment on the amount of penalties for a more clarificatory nature for the audience. Mr. Snehal, please come in.
Yeah, thank you, Pritam. After going through Ashish's presentation and Gopalji's view, basically on this circular, the prima facie 2-3 things before I start on the quantum discussion. I would like to take you through a repetitive part probably, but understanding that this is the circular has been issued by IBBI for IPA to amend their bylaws to bring in within their bylaws a penalty to be charged to the IPs for contravening 14 items that has been mentioned there. They have given the quantum of penalty on the minimum side and on the higher side. So first on the quantum, where specifically the discussion needs to be understood. We will discuss the circular, whether it is going to hold through down the line, whether it will be a valid circular, whether there is a things that will be different. But if it passes the test, legal test, and if it is to come through, whether the quantum that is prescribed on the higher side and lower side, whether it is righteous quantum, whether it is more, whether it is less, whether you should have a more penalty on the upper side or lower penalty still on the minimum side, is what I would like to discuss first before we take it. So assuming that no one is going to raise the voice, no doubt this today's session has been done so that we do a representation through IP Foundation and reach out to our regulators, reach the voice, and our voice be reached there with the members' strength that has been there for today. So the idea for this organizing this event with transition is to have a maximum IPs to come forward, give their views, and based on the views, and collect the information based on the views and represent to the regulators. So here the first is upper side penalty is always a welcome. Lower side penalty as a IP, I don't feel that there should be a lowest penalty, and the penalty, the circular, which does not say anything on the basically the principle of natural justice, that whether timing, but whether you will be given an opportunity of being heard. So as the process, what Ashish described in the initial slides, that this will be on the third part. So you will be issued a so cause notice. Thereafter, you will be representing to the so cause notice. Thereafter, when the penalty is to be described, the penalty is to be levied. Then to have all the three IP on the same level of levying penalty, this circular will come into play, and the IPA can levy this penalty on that lines. But whether these penalties will be the penalties that IPs will be able to take forward the things, how IPs do understand these penalties. So when you go ahead with the circular, and when you see on the contravention part, the first point says that fails to submit disclosure. If I fail to submit disclosure as a IP or fail to submit a return to IPA or submit inadequate or incorrect disclosures, there is already a penalty for late filing if I fail to submit. So this is a double thing. Again, that is a fine that the late penalty is levied in case I am not filing on time. Again, this will be a monetary penalty levied. So for the same offense, I will be charged twice, one for late filing. So we can have a distinction understanding probably here that the late filing fine which is there is for the issues of minor nature, where the penalty is levied to the IP for late filing, and here where the so cause notice has been issued and there is a mens rea or guilty mind found of the IP throughout the process that he has carried out, and in that scenario, this penalty may come into the picture. So here, this penalty, we need to understand that maybe from that perspective, where the IP has been found of guilty of mind through this process, and he knowingly has not filed a disclosure, knowingly has not filed, given the inadequate things, then this penalty should be levied. This is my assumptions of understanding the circular, but we need to have a clarity on this as well, so that my understanding and the understanding of the regulator probably is on the same line. If my understanding is correct and if it is to be done, then that should be also that minimum penalty what has been mentioned should also be discretionary in nature, because there may be a IP who inherently did some mistake, maybe not unknowing, maybe knowingly, but it was not his intent to create a problem for or give the wrong data, but because it was consequential in nature. As a IP, we all work on the very tight, walk on the very tight rope. We have to perform at the CDs level, as well as we have to do submissions at to the regulators. Too many submission to the regulator is killing our time. So a submission on that synchronization from IPA, we have to file our quarterly return, monthly return. Above all this return, we also get a mails that you file additional detail on these things, whereas already that data has been already shared to them. So now, which are the data they are asking? Which disclosure they are asking? The mails that they send to us, or the where we have to send the data within 5 days, the main days, the monthly reporting, or is it the forms that have been asked to us to be filed on regular basis, like CRP, IP forms, form 2 and 3? So a clarity on this part by the IPAs, and giving the assurance to the IPs that the IPs will be penalized probably if this chart is put, if they are found guilty of their work, then only this will be levied. It's a welcome stage because this will help the profession to grow and have a very strong integrated professions. The professionals who actually do a lot of compliance and take it on further. The other points that you have on contravention is acceptance of assignment, having conflict, failing to maintain records properly. So here in all this, most of the things are 14 points that we have. The most of the points are basically very subjective in nature unless the clarification comes out that what do you mean by properly maintaining of record and what are the records during CRP that you need to maintain. There is no clear cut guidance on that. All IPs maintain the records as per their formats, as per their wish, and then the things are meant. So when the inspection comes, when the IB out of the four anyone has complained and the proceedings are against the IP, a so-called notice is issued, when he has to produce the records, what will tantamount to proper? Same reject of claim again. It's a very subjective matter. As such, there are pronouncements which says that IP has no right to reject the claim. He only has to collate and then accept the claims. So this rejection of claims is something which needs to be debated on. Fails to comply the direction of adjudicating authority. Yes, adjudicating authority direction, if IP fails, a penalty can be initiated. But something on the side of adjudicating authorities also needs to be done. The timelines to that has been given in the code and regulations that needs to be followed. If not, and in case of urgency, when the adjudicating authorities are approached, if they are not supporting the IP, how do IP perform? Outsourcing his duties and obligation, very broad pointer to levy penalty. Appointment of registered valuer, okay, understood that if that is not followed, but in certain cases, the COC does not allow you to appoint. They are not ready to ratify. In case where their appointment is done, ratification is done, not done, that time there are a lot of issues on these points and lot of litigations on the IP starts on these points. So when there is a whole sort of points where IPs is made liable for penalties, there is no support from the regulator whatsoever in the nature in these lines, or even on these points what the penalty is being discussed for the IPs that to be done. And over and above the change in the model bylaws, when what Ashish ji pointed out, changing from section 224 to 222, so the funds to be raised to pay which can be used by the IBBI for their routine matters, that to be raised from the IPs, this is really conflicting in nature. Because in case if there is a lack of fund, the penalties that are of substantial nature which are being levied can be imposed, as the mandate clearly says that IPA has to do the amendment in the model bylaws. And as Ashish said, that MD of a IPA may not be in position to say no to this amendment. Same way, penalty to be levied if it comes to a mandatory to the IPs for the collection to be done, then I think we all IPs being assisting to resolve the others issue will have to look to how do we resolve our own issues in these lines. So with this small points or pointers on this point, quantum part, I keep the forum open and the Pritham to take the discussion forward amongst the panelists to be taken forward on these lines.
Yeah, thank you, Snehalji, for your deliberations. It was definitely very relevant, and you pointed out the subjectivity part, and there are the conflicting interpretations on the points. Now, for the next part, I would request Ashish sir to give a short observation on the legal sustainability of the circular. And along with that, I would request him to comment on the prospective or the applicability time, prospective or retrospective also. So Ashish sir, to you.
Okay. I think, you see, the main issue now remains is the legal aspect, which is whether this particular circular is legally sustainable or not. I think in my earlier presentation, I've already covered that 196 1P very clearly says that they can issue necessary guidelines. So I will treat this circular as a guideline for the IPA, which obviously IBBI can do it. Now the question is whether they can also dictate that what should be the quantum of the penalties, because at the end of the day, if we look at the code of conduct, if we look at the model bylaws, it says that it is the discretion of the IPAs to levy the monetary penalty. So as I think our friend Dr. Raju has mentioned, I think this should be left at the discretion of IPA. I fully support that. That there is absolutely, you see, those IPAs are also regulators. So let them also see, because the discretion is very important. Sometimes you say that minimum 50,000 has to be imposed. Well, if the particular, you see, the issue is not that much, I mean, the non-compliance is of not that critical nature, then why even 50,000? Maybe one can impose only 5,000 rupees. Maybe one can impose only just as a matter of like you're being put under some kind of penalty. That's all. So sometimes you don't have to, every time you don't have to teach a lesson to somebody that yes, the minimum penalties have to be in the range of 50,000 or 1 lakh rupees. So these are little, you see, over the board, I would say. Now, coming to the aspect of whether it is retrospective or it can be prospective, let me share my presentation once again. I think there are 2, 3 more slides which I did not cover earlier. So let me deal with this. So this is, of course, I've already covered. So I'm not dealing with it. You see, as far as section 196 is concerned, yes, 196 1P, I'm showing it to you again. Issue necessary guidelines to IPAs, IPs, and IUs. So definitely IBBI can issue guidelines, and this circular forms part of the guideline. So here it is covered. Now coming to 196.2, where they are talking about model bylaws. Now here they are talking about grounds on which penalties may be levied. So 14 grounds which they have already given. Well, grounds they can dictate. Then it says, and the manner thereof. Now, manner thereof is something, what I understand is how it is to be implemented, the manner of levying the penalty. It does not cover how much. How much is definitely talking about the quantum. So I think this is slightly where the IBBI probably has gone little overboard on the quantum part of it. So quantum should be left to the discretion. Okay. Now, whether it is this circular, this circular will be prospective or retrospective. Friends, I think I've already mentioned. Number one, IPAs first will have to amend model bylaws. So today, as IPs, we must unite together and make representations to all the 3 IPAs. Of course, with a copy to IBBI. Because you see, ultimately, they will have to amend the model bylaws. So we should tell them that, look, if you amend the model bylaws, incorporating this chart, now this is going to create some legal troubles also. So this is something where we can, as we can put as a pressure, or we can put as an advisory. I'm not saying that we are at warpath with IPA or we are at warpath with IBBI. Definitely that is not the objective. Objective is that your sound should be heard, that your voice should be heard. Now, what better face is that if we stand united? Now, that's what is extremely important today, isn't it? Now, let us look at whether it is prospective or retrospective. I'll take you to a different, you see, platform, you see, horizon altogether. This is one Supreme Court judgment, friends. All India Reporter 2000 Supreme Court 3344. It is easy to remember. H.B. Pancharappa versus K.G. Ishwar. Now, this is a 3-member bench judgment of Honorable Supreme Court. And this was against an advocate who was being held guilty of professional misconduct. Look at what Supreme Court says. A charge of professional misconduct is in the nature of a quasi-criminal charge. Look at this. Such a charge requires to be proved in the manner of proving a criminal charge, and the nature of proof required to prove it is that of beyond a reasonable doubt. So today, if any of the 3 institutes wants to start or begin, say, disciplinary proceedings, and then they have to come to a conclusion whether the person is to be held, whether the chartered accountant, cost accountant, or company secretary, or even advocate also, have to be held for professional misconduct, well, the charge must be proved beyond a reasonable doubt. This is extremely important, friends, because they say it is nothing but in the nature of a quasi-criminal charge. So it cannot be decided on the basis of preponderance of probabilities. I think my friends are aware, those who are lawyers, well, they know that the civil matters are decided on the preponderance of the probabilities. But the criminal cases are decided beyond a reasonable doubt. Because the idea is that, you see, 99 people may escape, only one person may be held guilty, but we don't want to hold any innocent person guilty under a criminal charge. So that is the logic, that is the jurisprudence behind criminal jurisprudence. But in civil matters, it is basically balance of you see, probabilities. Who is speaking, you see, higher truth or lower truth? Because you can't really find what is exact truth. But कौन ज़्यादा सच बोल रहा है? I think that's the way on the basis of that the civil matters are decided. But the matters of professional misconduct, now I'm coming to the straight to the point, whether it is of a CA or a company secretary or advocate or cost accountant or even an IP, now they will be considered as a quasi-criminal case. And the balance with which is and the nature of proof which is required would be beyond reasonable doubt. Now, whether these IPs will go into these kind of IPAs will go into these kind of details, that's one question. But let's come to the prospectivity or the retrospectivity. There, actually, I wanted to prove this, so therefore I've just shown you this. Now, look at this. The penalties, because which are now kind of, you see, the monetary penalties, because this charge is like a quasi-criminal charge. If I am doing an act today, I must know what is the penalty against me today itself. You can't say that you have committed the act 1 year before, but today we are going to charge you with this much penalty. This cannot be retrospective at all. Looking at the entire gamut of things, drawing the conclusion on the basis of the Supreme Court judgment in Panchrappa versus KG Ishwar, penalties cannot be retrospective because it's like a quasi-criminal matter. What I'm trying to say is that any conduct which is complained of must be after the date of amendment. So once the IPAs are amending the model bylaws, now if your conduct is complained of arises because of certain non-compliance after that amendment date, well, then the penalties can be imposed, not for the past period. So this is exactly what we are looking at it. So law existing on the date of commission or omission of act should apply. This is the basic principle which the courts all over the country, they have decided, including the Honorable Supreme Court, and not in one cases, many cases altogether. But I brought it, you see, the specific case of a professional misconduct. So what does not matter is the date of imposition of penalty or date of start of the disciplinary proceedings. Somebody cannot say that, look, we started disciplinary proceedings after the amendment of the model bylaws. No, that will not cut ice. Or the date of imposition of the penalty was also after the date of amendment. No, that will also not cut ice. What matters here is the date of commission or omission of an act which is complained of. That means the non-compliance complained of. If the non-compliance has happened prior to the amendment of the model bylaws, I cannot be imposed this penalty. But if the act complained of is after the date of the amendment, well, then yes, I can be grilled if obviously if they amend it. Well, of course, that's another matter whether the legality is challenged or not. But my friends, my very important point is that let's not you see look at you see these things in a very narrow perspective also. What I have seen in many cases that people rush to the court without any preparation. We have seen in the case of AFA also that writ petitions were filed. Look at where we stand today. Nothing has happened. No stay was granted. The notice was issued in a very ordinary manner by the High Court. Well, the notice date was one of the dates, and on that date, now the new date has been given. By that time, you see the matter is decided fully, and finally, probably the period for the AFA will also be over. What is the point of filing such writ petitions? Well, if we have to go to the court, my dear friends, let's do it in a very concrete manner. First of all, let's follow the steps. Whether we are happy or not happy, obviously, now the comments of or the feedback or the inputs of the participants are required at this stage. If they feel very strongly about the circular, which I'm reading, you see a lot of WhatsApp messages in many groups, and I am also reading the messages in the chat box. Yes, there is an impression that this circular has to go. So what steps need to be followed? First, we have to remain united. That's one of the important things. Let's not file, you see, left, right, and center the writ petitions in different high courts. That will not serve. Number one. Number two, first, let us follow a course of action. Let's make a detailed representation, or maybe you see there are I don't know how really has to happen, but there are a lot of websites are also there where you can sign a petition and all that. But that's that apart. The actual representation has to go to the IPS and the IBBI, isn't it? Somebody must take responsibility to do that based on your comments today. I think that should happen. And once that concrete thing goes, any comments which are there, they should be very point wise, specific points should be mentioned in that representation. Let us wait for that representation, the outcome of that. Let us wait whether the IPAs are amending their model bylaws or not. Well, if you ask me a question, IPAs are going to, you see, amend their model, but they have no option. Let me tell you very bluntly, they have no option, but they're going to do it. But if we start putting that kind of a, you can say the representation or the pressures, well, obviously they're going to have second thoughts also. So that is the first step which we must take. If that does not happen, and of course with the representation, with the copies to the, even to the Ministry of Corporate Affairs, Minister of Corporate Affairs, even to the PMO also, I think let's not leave any stone unturned if we are not happy with this particular circular. And then of course we will explore the legal possibility. So let's not rush to the court immediately where we are not going to get any relief on an immediate basis. So that's my suggestion. I will leave it at that. Over to you, Pratim.
Thank you, sir. Thanks for the giving a second time the legal perspective of this circular and the consequences of the applicability. And it is very clear that from the legal standpoint as it stands today, that any act of omission, whatever, is, after the law is amended, that will be impacted, not anything done before that. So with this, we'll go to the question answer session. Before opening the floor, and I will take the questions what have been given in the chat box serially, and try to pick up the questions only because there are some observations also, which I will try to avoid, but I'll take up the questions. But before that, I'll come up to the panel with some specific questions that is already there that has been assimilated. Sir, to start with you, I just want to ask one thing. One, you have pointed out, you have touched upon. Sir, the initiation, because we know there is a disciplinary committee of IBBI also, but you in your presentation say that it will be IPS disciplinary committee. So who will initiate the process? Is it an addition to the IBBI disciplinary committee, or it is a sole IPS disciplinary committee? How to start with? So who will be starting this?
Okay. Pratim, it's a good question. It's an excellent question, but let me clarify for all my friends. The IPs are subject to the disciplinary, you see, committees of both the regulators. One is IPA and other is IBBI. Right now, IPAs are not very active in their disciplinary actions. We have seen that. Most of the show cause notices, the people or the inspection and investigation, because then there are, you see, even there are so many words which are there which one must understand. There can be a grievance, there can be a complaint, there can be an inspection, there can be investigation, then there can be a show cause notice issued, which is generally nowadays issued by the IBBI, and IBBI process starts with the show cause notice, then your reply comes, and then they can the matter goes to the disciplinary committee, and then the punishments can be awarded. And we have seen many orders which are already there on the website of IBBI. Similar manner, IPAs also have the power to initiate disciplinary proceedings. So this is in addition to IBBI. IBBI monetary penalties are not defined anywhere. It is their discretion. But insofar as this circular is concerned, this is only with respect to the power of the IPS to to initiate or whatever they have to decide on the disciplinary proceedings. So it is a separate, and it is in addition to IBBI. Let me clarify that. Okay.
Okay, sir. Yeah, now we are very much clear that how it is positioned in the overall framework of the regulators who are regulating IPs. Now, my next question will be to Dr. Raju. Dr. Raju, one perspective, it's a perspective, I just want to take your view that whether an IP can take it as a grossly compliant circular. So that what I mean to say that a IP who is otherwise grossly compliant suddenly misses one thing out of his. You also mentioned in your in your speech that suddenly something has been missed. So is it intended for that also, or there will be some cognizance of the gross compliance of an particular IP? Dr. Raju, your view.
That is what I was making the point very clear, that it should not be the wordings that has been put is very dicey. And I mentioned one point that IPAs are also tier 2 regulators. When IBBA, they have powers to quantify the penalty. Similarly, you have to leave it to all three devs, the three IPAs, to go through the process. They will initiate the process, and they have their own mechanism. They have the learned, very expert people in their disciplinary committee, and you have to leave that that particular forum to them, rather than giving them the minimum and maximum and 25%. So it can even be more than that. It can be even less than that. For example, it all depends upon, as you said, not grossly negligent, but there was, and even in the, there are provision, even in the code is also there, and also regulation it is there, that a warning can also be given. A minimum warning can be given. Now here, there is a direction given to go for a minimum penalty and a maximum penalty. Only when they decide to go for a penalty. So this is a place where they have to very clearly quantify, qualify when they will use this particular penalty clause. Number two, I will only treat this as a bossing over. When you have two-tier regulation system, and you have already codified with respect to code and the regulation, and giving an additional circular to an IPA, giving minimum and maximum, it is like bossing over. Maybe you can boss over them as a ultimate regulator. IPAs are also coming within the fold, but there are certain aspects where they can do that. It is like stepping into their shoes. Now, similarly, the same question can also be put when there is no limit for IBBI, minimum and maximum, they can quantify themselves. They are also human beings. They are also human beings. So they are not gods to actually judge themselves. So IPAs also, you have to leave it to them. And they are the extended arm of IBBA is a new regulator. They are born only in the year 2016. But these three IPAs, they are the offshoot of a 1949 institute, 1959 institute, 1980 institute. Definitely IPAs have a strong grounding in profession. You have to leave it to them. So that is, maybe this is one place where IBBI have to actually understand the core strength of the professional strength of, because all the professionals, majority, if you take the number, 54 plus 18 plus 5, it's 23. So 77% of the, almost 80% of the insolvency professionals are only from these three institutes. So therefore, let IPAs take a call rather than bossing over them.
Yeah, nice. Very interesting interpretation. You wanted to say that all the IPAs have much more administrative experience than the newly born.
I will also want to make one more point, which I made it. This part 4 can be suo motu taken by the respective three institutes. So if at all there is a negligence on any of the 14 contraventions, it will also impact his main profession, the particular professional's main profession, being a chartered accountant in practice, cost accountant in practice, company secretary in practice. So therefore, that is also a major concern. So this is the part 4 is so far it was not, it was a sleeping giant. Now you are making the giant to get up. You have now got a brother that side. Now anything happens there, you can also get the power from there. So it is something like that. You have to leave it to the respective institute.
Yeah, good. So now I have another question to Mr. Snehal. What is actually implied by the term fees? Now it's it is also very openly defined fees. Now fees, what is the entire fees of that particular assignment? What is the monthly or about it monthly fees? Or if it something happens in the midway of a CRP process, then to the fees already accrued or to be accrued, how to interpret these fees? What is your perspective?
Yeah. Pratham, on the fee perspective, on the quantum of fees, like 25% of 1 lakh or 2 lakh, whichever is higher. First of all, my view, any penalty on fees, if they are putting, then where is the circular on the fees part? There, whenever it is mentioned in any of the stakeholder committee meeting, which has been attended by me or any of our friends, it always comes to a conclusion that it is a mere share of demand and supply, things which constitute our fee component. But when the penalty is to be levied, quantum is to be decided 1 lakh or 2 lakh, whichever is higher, or 25% of fees, whichever is higher. So you want to take the benefit on your side on the fee part. And when it comes to fee, there has been initial also, there has been fee of 0.25% on the fees that is being levied on all the IPs, which has to be paid annually. Whether they receive the fees or not is also a question, but on accrual, fees has to be paid, but no support on the fee part. Now, the question that you exactly raised, that what is the fees they are talking of? Because if we are talking of a resolution plan, which has been rejected, or claim which has been rejected, for which a penalty is being decided. So is there any component of fees compared to for claim verification? This is the fees that you are having? No, the fees is always on a monthly basis or a lump sum basis that is being charged. So do they want for a non-compliance of the claim verification? Do they want for in case of a non-compliance of a resolution plan that is there being put forth, the fees of the whole exercise that the RP is carrying, on that 25% they are talking of, or they want the fees component of the RP to be divided amongst all? So they always keep it vague. Till now, 0.25% fee levy, which has been done, that circular came, everyone is quietly paying that money, but no one has raised on the what is the fee on which that 0.25 has to be paid. So this is been a regular trait on the circulars that come on fees, where they have a collection to be made from us. But when we have to collect as a IP from the COC, then there is complete pin drop silence from the regulator side, from the adjudicating side, and it's a really challenging things. So further commenting on the fees, I would again move back to you, because I think we have good points to be clear for our representation. But this would be enough for the others to put for thought for everyone on this.
Yes, definitely, sure. So, Ashish,
okay, Pratim, I have a suggestion. Now, what we do is, because I can see a lot of hands being raised, I think the idea is to collect, you see, feedback, inputs of all our friends. So what you can do is, you can go to them one by one, but ask them to be very brief, obviously, because the time is pretty short. But we want to hear all of them. And also, in the meantime, you can take some few of the questions or observations from the chat box also. I can see Mr. Ravi Bagri. He was the one who raised his hand first. So maybe you can go to him first and then ask him to unmute and maybe other.
Sure,
I leave it on you, but that's my suggestion.
Yeah. No, definitely. What it's a good suggestion to slightly sip in the participations. Yeah, Mr. Bagri, there have been quite questions in the chat box also that I will be picking up. So Mr. Bagri has raised his hand first. We have all seen from the very beginning. Mr. Bagri, if you want to say something on, or if you then you can be unmuted.
Yes, sir. I even want to ask to Snehal sir also. I've been associated with him, like, talking to him on these matters in terms of improvisation. But this is very important question, that how it's like a fiefdom in terms of the circular, because I've never heard talking to the IPA team also, like, because what is the motive of bringing? It's only revenue motive. There are a lot of mechanisms which can be developed by IPA to, share the revenue. As Snehal sir has rightly pointed out, that they have never discussed about the fees and all. But here, if you see, they have not left any corner for us to put it into the factor and charge the fees. And the fees, well, everybody knows it's a very draconian in nature by default. Because if I say in one of my cases, IP have not got even a single penny of the fee after 13 months of running the entire CRP process. So these are the factors which has to be taken very seriously by the whoever will represent from us, because at least from my part, I can say I'm totally very supportive of any person who is taking up this cause till wherever it goes. I had even tweeted to PMO and all that these are the matters which are happening, and this is very this is not a good thing which is happening for the profession. That's what I can say. So if I could get at least update by IPs whether this was even discussed with the IPA team by the IBBI management.
Surely. Okay, Mr. Bagri, we can understand your point, what you wanted to communicate. Let us again. Now, what I'm doing, I will be picking up one because questions are also lying in the chat box from the very beginning. So now I take a couple of questions, then I will again go to one of the participants to take the. I think next Mr. Santanu Ray has raised hands. So, and there are other hands also. Let us take one or two questions from the chat box, then I will again come to the participants. One question was there the very beginning, Mr. Krishna Mohan. His question is that at serial number 6, the outsourcing is duties and obligations. Now, what he's saying, I have a team of people. Some of them, of course, are IPs, CMAs. They assist me in discharging my duties. I compensate them from my fee earnings, etc. One of my team members sits in the unit to have administrative control. One of them calls for information and other directors from the suspended information from the suspended board. They do everything in my name only. Does this amount to outsourcing? So this question I am coming back to Ashish. What is your interpretation on outsourcing, specifically on this question?
I think we are all clear what is outsourcing. Outsourcing is that I'm not doing anything. I'm just handing over the entire assignment to somebody else. Now, that's not the case here. What he's done is he has appointed professionals to run or manage the company or run the factory or to do maybe accounting or auditing or something like that. This is basically, you see, he is taking the help of professionals. So this is not considered as outsourcing. Outsourcing is I'm sitting at my home getting maybe 10% cut and I have handed over the entire assignment to somebody else. So that's known as outsourcing. This is not outsourcing.
Okay. Yeah. That's very, yeah.
Thank you very much,
yes,
sir.
yes.
Thank you.
Pritam Snehal here. I would like to add on this outsourcing thing. It's a very clear thing. If you are paying from your pocket to the people in your team, okay, the disclosure requirement is already there. When you appoint any professional, disclosures are to be made and disclosures have to be filed. So when you are filing a disclosure, that means you are taking a separate fees, and that is what you are outsourcing. If I'm building my team, it may be on a fixed term, fixed pay expense basis or a variable expense basis. But if it is from my own income that I am charging as a RP fees and sharing from that, then that would not tantamount to outsourcing in my view.
Okay, sure. So next, I am taking up one participation. Mr. Santanu Ray has raised hands from very beginning. So, Mr. Ray, you can tell what is your.
Good evening. Good evening, everyone. My point is, I think in our representation, whatever we are going to make to the IPA, my suggestion is, firstly, we should ask them whether all these fees, all these penalties totally can exceed 25% of the fee earned by the IP. If there are 3 violations, 4 violations, the question arises whether can it be 100% of my fee or can it be more than 150% of my fee if you total it out. Secondly, will the fee considered a gross fee or the net fee? By net fee means, let's say I have a IPE to whom obviously there is an agreement, and certain share of the fee goes to the IPE for the support service. Now my earning is net of that, right? So, and obviously separate bills are raised by the IP and myself, which is allowed under the law. So when they take into consideration this fee, will they take my net fee, which is my share of the fee, or will they take the total fee? You know, in which case there is a problem. So these kind of clarification, firstly, whether the fee total, total penalty, I'm interchanging the word, the total penalty can exceed my earning in a assignment. That is something, a big clarification is required, which should be even made to IBBI directly. So I'll rest my two submissions on these two things. I would welcome comments of the experts.
Okay, I
Okay,
think
so
this is a very good point which you have raised, Mr. Ray. I think these are point to be noted. I think you have been very brief and succinct, so thank you for that. I think we'll give opportunities to others to give their comments in a like manner. I think he raised a very important question. Yes, over to Pratim. Over to Pratim.
yeah, sir. I am taking up another question which is there in the next thing. Mr. Virapandian, N. Virapandian, he has a specific questions that what is conflict of interest? It accepts an assignment having conflict of interest. What he says that conflict of interest has been defined under section 146 of the code, resignation by the bankrupt trustee nowhere else, but not in any other place on the code. Please clarify how to define it.
Okay, I think everyone is aware of what is conflict of interest. The conflict of interest is that, you see, you should not have any related parties who are working for you and you are sharing your revenue or you're giving them assignment. So I think everyone is aware of what is meaning of conflict of interest. We don't have to really go into the detailed meaning of that. But yes, once they are talking about the penalties on a conflict of interest, a proper definition of interest should be there. There is no quarrel on that. I think that should also be. So good point. I think that this can also be noted. Yes.
Good. Sir, now Mr. K. Venkata Raju has raised hands also. I would request him to put forth his observation, what he wants to say. Mr. Raju, please.
Yes. Sorry, my mic was.
No. Mr. Raju wanted to. Mr. Venkata Raju, K. Venkata Raju.
He has to unmute. He is on mute.
Please unmute. Mr. K. Venkata Raju.
Maybe you can go to some other.
Okay.
Yeah.
Now is it audible, sir?
Go to some other.
Yeah.
Yes, Mr.
Okay. I have got two doubts, sir. Whether the penalty is to be calculated on the fee accrued or fee received. One thing. Number two, in most of the cases, the assignments are such that it is paid only on monthly basis, monthly amount of certain amount. So we cannot say what is the exact fee because it is unfinished. So in that case, how to calculate the fee on which this 20% penalty should be charged. And third one, regarding the circular, for example, point number 1. What is the maximum fees? Is it 1 lakh or 20%, whichever is higher, subject to minimum? There is some clarification missing. In case of failure, in case of serial number 1 of the circular, what is the maximum penalty? Tell me, sir. Because there is some ambiguity. 1 lakh or 20%, whichever is higher, subject to a minimum of 50,000.
Okay.
These three questions, please kindly clarify. Thank you.
Okay. See, if you read the circular, on every point they have mentioned certain amounts, say 1 lakh or 2 lakh or 25%, whichever is higher. So that is the higher limit. So higher of that has to be seen, right? Supposing you were drawing a total fees of say 10 lakh rupees, 25% comes out to 2.5 lakh. So it will be either 2 lakhs or 2.5 lakhs, whichever is higher. So that's the maximum they can impose. And minimum is they have no discretion to go beyond below this. So minimum is like 50,000 or 1 lakh rupees. They have to impose. Supposing they decide to impose, then they will have to impose the minimum. But maximum could be that limit of the higher of that.
Okay,
So I don't think there is any issue. Well, as far as your fee accrued or fee received is concerned, well, I would say it is fee accrued, because received has nothing to do with it. So because at the end of the day, you are going to receive it, not today, maybe tomorrow or day after tomorrow. So I think it will be based on the fees accrued. But yes, I think some clarification is necessary in this from IPA as well. Yes, I think we can
Okay.
move on now.
Yeah, yeah. Mr. Shovik Roy has raised his hands also. You can, Mr. Roy, you can put your observation, what he wants to say.
Good evening, everybody. See, my observations, though more on the legal side, may perhaps be incorporated in the representation also, if others agree, because arguments remain the same. Now, looking at it from the perspective of administrative law, rather than only IBC, uh, the doctrine of proportionality and the test of reasonableness, whether this test has been met by the circular, by this draconian circular, and is the doctrine of proportionality followed by a minimum fee, a penalty of 50,000, especially with that 50,000, as rightly pointed out by Mr. Shantanure, can be 150 times all of your net earnings. Because there are many IPs who are new in the field and possibly not getting a monthly net fee of even 50,000. And as assignments come on pre-pack, and at some point of time, IBC is notified for individuals and partnerships, the fees will become even lower, but the circular would continue to apply. So is the test of reasonableness satisfied? Is the doctrine of proportionality met? That is one point. The second point is this kind of a huge minimum penalty. I mean, I am reasonably new to IBC, but I've been in taxation for a number of years. This kind of penalty is really not been seen even in the revenue laws and the tax statutes. For example, the general penalty in GST is 10,000 or tax evaded, whichever is lower, or 25,000 or tax evaded, whichever is lower. And that brings me to another point, that where is the circular relating the minimum penalty to the quantum of loss or prejudice which is caused to the victim of the so-called misconduct? Because even in the IBC itself, we have section 220, which has tried to relate the penalty as 3 times the loss caused. So at least there is a correlation like the revenue loss to the injury suffered by the victim. But the circular does not say so. So 50,000 and all this most seem to be just some arbitrary figures. Secondly, coming to the issue of virus or ultra virus. Now, it is true that 196(2) does give the right to the IPS to determine the manner of imposing penalties and even perhaps the quantum. Now, whether so it is like a delegated legislation given to the IBBI and IPS to impose the quantum of penalty. But can it be done directly through circular? Because again, taking the analogy of revenue laws and tax laws, in every tax law, the quantum of penalty is always given in the section in the statute itself. Neither it is given in the rules and definitely not in the circulars. Circulars are mostly clarificatory in nature, and whenever circulars have tried to impose something harsh or beyond the statute, it has always been struck down by the apex court. Now here, the quantum of penalty is not even been brought into the rules. Forget about that main statute itself by the lawmakers. Forget about regulations. It is directly brought through into an administrative circular.
Excuse me, Mr. Shavik. Could you please come directly to your question? Please. We are running short of time. Please.
Okay, I think he has already.
The question is that the test of reasonableness is not been satisfied by the circular, and the virus can also be challenged.
Okay, I think Mr. Roy, you have fantastically, bring forth two very important points: doctrine of proportionality and reasonableness, which are legal points. So I think these points have been noted down. So I think they will also be taken up to the IPS. As far as the circulars and other things are concerned, this circular is advisory in nature to the IPS to amend their law. So once the IPS do that, well, then it will get affected, not through a circular. So I think that I've already made it clarified also. So, but thank you so much for your observation. I think the time is short. We have to move on to the all people so that everyone can contribute. So I think Mr. Shivnanda Sharma was waiting for quite a long time. I think we can ask him to unmute and maybe we can move on to him. So
yes. Kijaji, first thing is that I'm aware that you are generally consulted by the regulator. Your written opinions are sought and all this. Were you not involved at all in this? It is a little strange. Because everywhere they try to approach you with a note or a legal opinion. So whenever you interact, kindly give a feedback that this is something which is not right. But I believe that whenever we represent and whatever be the content of our representations, and if succeeds, still there will be issues and penalties for non-compliances. But the present system which is happening is quite difficult. So can there be a system of insurance and any mechanism where an IP is covered, because the premiums are so high, insurances are not covering these costs. So can we also try to make a representation to some underwriters or have some fund within ourselves? Number two, I have found that a lot of frivolous complaints against peers are raised by our own IPAs, and those frivolous complaints are not only taken forward, very dirty statements are made, IPAs are made football, and why we can't get together and take action against our peers, because they are the one who generate these kind of instances. Majorly it is a complaint which is triggered by our own peers. I can name people here who are sitting here who advised wrong things to their client. You know things where people make wrong statements. Why can't we have a structure like a bar council or something between ourselves? Like very well, Dr. Raju said that this is one thing where we are getting a cohesive team. So why we can't have a bar council kind of a structure and take care of those peers who are actually triggering all these things, giving unprofessional advice to their clients, reacting unprofessionally, making wrong complaints. God bless you.
Okay. So I think your points are well taken, friends. Pratim, if you are there, you can take over.
Sir, that was an observation, whatever informed. So I would next go to Mr. Akhil Ahuja. He has also raised hands for long. So Mr. Ahuja, you can tell whatever you want to
tell. Thanks, Mr. Pritam. So I have no, I don't have any question as such. I have two very specific suggestions apart from the points that have already been discussed. First, there is no doubt that this circular has been very poorly drafted. If we're going to read it, this is very clear that it has been poorly drafted and must have been issued in a hurry. So our representation letter should include the pointers. What could be the hurry for issue of the such circular? Apart from this, what are the incidents or the observation the board has seen in the recent DC order that they have come up with this DC order? And they should have a roundtable discussion with some selected IPs, like Mr. Sharma has just mentioned to Mr. Makhija also. So there should be a roundtable wherein 5, 10, 15 IP representatives should be there while finalizing such circular. The second suggestion that I have, if you see from the macro basis, under the insolvency law, there is a requirement of an unavoidable transactions. In the last 5 years, there is such no update on the avoidable transaction, either at the legal angle, either at the NCLT or at the High Court level. What could be the reason it would be? But when we're going to have a discussion with the directors on the ground, it is actually demeaning, or it is actually decreasing the aura or the professionalism of the IP. Because the director is also going to say, okay, if you have the law, you're going to take it up my company. Okay, you can take it up. There is nothing going to be happen to me. The PUF transaction is not going to be adjudicated, and you're going to be face a lot of criticism, penalty, even from your parent body itself. So that are the two specific suggestions that I want we should include in our representation letter.
Okay, thank you, Mr. Ahuja. So we will go to the next question. There is a couple some questions, but see, because of the paucity of time, we would not be able to.
So will you allow me to speak a question, please? I'm raising my hand since now.
Oh, acha, acha,
So
yeah, yeah.
just one thing, Mr. Preetham, if you can, either Mr. Ashish or Snail can revert either on the unavoidable transaction stuff.
Yeah,
Yeah,
Mr.
please.
Yes, that's, but Mr. Sharma, you can raise whatever issue
Yeah.
you want to raise, please.
Okay. Thanks for giving me the opportunity, Ashish. This is very important. I'm going to raise 3 questions. What are your suggestions for the role of IPA today? With the background, because the IPA get constituted in 2016 and 2020-21, all 3 IPA, they have to get their license renewed. So practically, the IPA is not in a position to raise the voice. In democratic setup, yes, IP can raise, but IP will not able to raise it. Whether can we say no to in our board and say that we don't agree with it? My first question, sir. My second question to you, sir. You see, if a disease there is always appellate tribunal. Then there is a high court, and you can go to Supreme Court also. So in case it is paid, it will to be paid if it is a law. What state it will be payable? And if somebody go to High Court, whether the High Court will have the power to reduce it, or with the circular will have a binding on the High Court and Supreme Court also. And my third question will be basically that being an insolvency professional, what is your advice that what we can do in a collective level? The 3 questions to Mr. Ashish Bhatia. Thank you very much.
Okay, thank you, Vijendraji. See, first is insofar as the license renewal is concerned, I've already covered in my earlier presentation when I was speaking that definitely I would not like to be an MD of an IPA because I know I cannot say no to IBVI. You also know that. You also know that. I think you have been at the helm of the affairs. You also know that. Can the council of any institute say no to the Ministry of Corporate Affairs? That's a larger question, macro question. We are not getting into that. But the only point is, looking at the interest of the IPs, I think someday or the other IPs will have to take a tough stand. That's what, can they say no for amendment to the model bylaws? I believe yes, they can. But whether they will or not, that's a second question. That's one part of it. The second is the question relating to the, you see, the matter which has been decided by DC, imposed penalty, somebody goes in an appeal to the appellate tribunal. Yes, appellate tribunal also has got all powers of the DC. They can obviously amend, remove, delete, or even higher. I mean, they can increase the monetary penalty also. So they've got all powers. So all appellate bodies, whether appellate tribunal or if it's High Court or Supreme Court, they can do any damn thing. Because it is very clear in number of judgments that what a DC can do, an appellate body can obviously do that because it gets that power. It's a continuation of the same proceeding. And third, as far as the IPs are concerned, that's a very big important question. Number one, all IPs have to stand united. Unfortunately, there is no common forum. Unfortunately. And that is what one of our friends are also saying, that we should have a situation like a bar council where we can represent in a joint manner. Unfortunately, IPAs are also 3 divided IPAs. Then all IPs are divided because there are, I can see number of associations being made. There is not even a single association which says that, yes, I can command out of 4,000 people, maybe 3,000 are with us. Well, unfortunately, we are a fragmented lot. Someday, some action has to be taken, and leaders like you or Snail Kandar or anyone, I think all leaders also have to come together. See, this is one of the things. First is, okay, supposing there is one association, there is second association. Can't we have a forum of all the associations? Let's have a forum of all the associations. Let there be different associations. Let there be Hyderabad Insolvency Professional Association. Let there be a Delhi chapter. No quarrel on that. But let there be a common forum on the top of it, like Association of Chamber of Commerce. So it's like a, you see, unity which will be reflected there. I think somebody has to take a lead on that aspect. Here also what I'm saying is one representation should go, which should be unique, which should consist of all the points. Now, if there are hundreds of representations going, that doesn't make a difference. You see impression. So idea is we should stand united. Maybe what we can do is on the representation, somebody can start asking for signatures of the IPs. Now, if you are able to gather, say, 1,000, 2,000 or 2,500 signatures, well, be that as it may, it gives a message. The message goes across. So I think that's what it is required right now. Okay. So over to you, Prateek.
Yeah, okay. So I'll go to another participant, Mr. Kameshwaran. I think he has raised for a long. Mr. Kameshwaran, you can tell whatever you want to tell to the to today. Mr. Kameshwar.
Yes, sir. Thank you very much for the opportunity. I have only one point to say. There should be only a single regulator. In our representation, we should mention the IP should be regulated either by IPA or by IBBA, and no dual regulation and no dual penalties. This should be my view, and kindly see that it is included in the representation. Thank you very much.
Okay, fantastic. I think no one can be a more brief than Mr. Kameshwar. We must applaud. Thank you so much.
Thank
And
you.
fantastic suggestion. Fantastic suggestion. Yes, sir.
Very good, very good.
Mr. Bayal, I am having a 30-second question. Can I get a preference?
Yes. Tell, go ahead. I was coming to you only the next thing.
Oh, great. Thank you. I am Vinod from Coimbatore. We are from Association of All India IPs. My question, recently, all IPs given a representation letter to IBBI regarding the AFA matter. Is there any result come out? If IPA's representation is not going to entertain by IBBI, can we expect any response from IBBI on our representation letter? That's the question specifically asked to Mahesh.
Okay, see, I will answer it this way. The point is, we should not be discouraged from, or you see, disappointed by one particular aspect on AFA that they rejected that AFA kind of representation of all the IPAs. See, the point is, it's a question of the life being affected today. Now, if we do not represent, the question is whether they will consider it or not. That's a separate issue. That's what I said. Let's make the representation first in a very, very cogent manner. One. Two, if they reject or they do not act upon it, we have got a legal recourse left out to us. So let's do it that way. So first is, we can't sit idle at our home by saying that they did not, act on the earlier representation. Therefore, we are not going to make it the second time. Let's do that. The more we represent and more united front is there. Like supposing I have said 2,000 signatures, 2,500 signatures. Don't you think it is going to make a difference? So then we can always devise a new strategy after that. What happens if this is not accepted? So that's what I am been, harping upon. Okay. Yes, I think we can move on to the other.
Yeah.
Preetam ji, can I come
yes.
in? I will be brief as possible. Okay.
Yeah,
Suppose
Mr. Sheshadri, tell me. Tell us.
Suppose we say that we don't have the money, whether it is real or not, and we don't pay the penalty after it is imposed. What will happen?
Out of the profession.
Well, see, the point is, I think the answer can be given in this way. Do you know that under Section 79, when a person is declared as a bankrupt or an insolvent, bankrupt, there is a question of excluded debt, right? Excluded debt is also there. But so excluded debt includes the fines and the penalties imposed. So therefore, this can be recovered. So whether you say that you don't have money, it doesn't really matter on that particular aspect. So penalties and fines are to be paid. Well, yes, if you don't pay, probably they can take your license and then can also take steps to recover. Please understand, these can be recovered as a revenue of the government, and these are serious matters. Okay.
Okay, sir, before going to next participant, I have a very technical questions. I think that every of the attendees will also have benefited. Sir, there is a on the circular in clause number 5, there is that there is an penalty on non-adherence to the orders by the AA. Now, AA is a quasi-judicial body, and if their order is not adhered to, there are mechanism they will come up with that. Can IBBI or IPA step in further to see that an order of an adjudicating authority has not been complied and they will be imposing penalty? Is it legally possible?
Well, ideally they should not. And they should not interfere. Now, I can give you another example. Another clause says that the rejection of the claim. Now, if the claim is rejected by, say, IP, RP, or by the liquidator, now what is the remedy which is available to the aggrieved person? The remedy available is very simple. They can file an application under Section 65, or they can file application, under the liquidation provisions, and they can challenge the decision. So when a decision can be challenged, if it is not challenged, it attains finality. Now, if I have decided a claim in a certain way and nobody challenges and goes to the court or tribunal, now can you come and say, I'll file a complaint against you? I think this is something you're going overboard. So these are certain things you are very rightly pointed out, that non-adherence to the orders of the adjudicating authority. Let adjudicating authority take a contempt action against me. Why you are bothered about that? You should be bothered about your, instructions. If I don't follow your directions or instructions, you punish me. Okay.
I think thank you, sir, for the interpretation. I think we are now absolutely at the fag end of the time. Neha, would you like to?
We can actually ask a few participants because they are there. So I think they can unmute themselves and quickly raise within 30 seconds.
Yeah.
We can give them, we can extend it.
Sir, here from Bangalore. I would like to ask a question. As you said, it's time for all the IPs to come together. So how do you intend to do that, sir? Because, we are so much fragmented. How do you intend to bring all IPs together and on a fast track mode? Can we do a symbolic protest, all of us together, maybe on 12th of August or 15th, 18th of August? Nobody will appear before NCLT or something like that. A strong message that we are not to be taken lightly. How do you give that force to all the people who are supposed to listen to us, sir?
Okay. My appeal to the leaders are there. I'm of course not a leader. I'm only an academic person. So the leaders who are hearing me and like Mr. Vijayendra Sharma, Ms. Snehal Kamdar, and many others are also here. Please get together. Please sit on a round table. Please unite everyone. So if you have formed associations of 200 people, IPs are here and there, come under a common forum. Let's treat it as a forum of IPs. Let us remain united, and then the things will definitely move in. So you decide the strategy in that forum itself, right? Like we are seeing in farmers agitation also. There are a number of associations of farmers, but they are united together in a particular one forum. So you decide your strategy, what you need to do. First, representation. Second, maybe a symbolic kind of a protest, what you are saying. I think the time has come. I mean, I will not say no to that also, because this gives a message. This gives a strong message to the regulator, to the ministry. I think everyone notices that. We are not disturbing anything. We are not saying that we are not going to do our duty. We are going to do our duties. Or what we can do is maybe we can wear a, black ribbon while we appear before the NCLTs. So, but today, of course, it is virtual. Nobody will see your black ribbons on your, elbow or your arm. But the point is, these are symbolic things which you must do that. And the more you generate together, more you group together, I think that's the answer where it lies. Okay. So I think, I hope Snehal and Vijayendra ji or other leaders are hearing me. They should form a...
I want to request you on
Ashish bhai. Ashish
bhai. Yes, sir.
Ashish bhai. Hello. Ashish
yes, sir. Go ahead.
Ashish bhai, I've got one question only. I'll take only 1 minute. You, that is Ashish Makhija, Dr. Raju, and Snehal Inamdar. All of you are a catalyst. And just you are all 3 days for all IPs. Now, we all are beginners. One thing which I don't understand about this circular, that if we beginner IP make a mistake, who will teach us? That is IPA. Now, IBBA says that whatever penalty which is being collected can be used for their internal fund, for their salary and other benefits. If I make a mistake, who will teach me? My IPA will teach me. So a suggestion before all 3 of you, let us you lead us and say that whatever you want to penalize, it is okay, fine, you penalize, but it should go to that external fund and not to the internal fund. Point number 1. Point number 2, imagine the cost of carrying of this insolvency process will going to be increased like anything. Now, if I am aware about from the beginning, I am a human being, I am going to make some mistake. And those penalties are not deductible under Income Tax Act. It's not the 25-30%. It is the compound effect will be much, much more. And let me tell you, on 7th August, Dr. Sahu, he is going to visit on a GIC premises where my son, he's trying to Snehal by you and Dr. Raju. He is going to lead about this particular Droginar circular and they are going to speak about this. My only request to all 3 gentlemen, please help that what point at least he should put forward before Dr. Sahu. This is only my humble request to all three of you, because all are three are a catalyst. You can do a lot of things, wonder. It's not that we can do. Sir, if we all are there, we are going to back you. For us, you are a three Dev. Dr. Raju says three Dev. For us, you are a three Dev. Dr. Raju, Snehal Bhai, and yourself. And I have undergone the training for all three of you. Thank you, sir. Thank you very much.
Okay. I think the point is noted. Yeah. I think maybe some of our friends, they can unmute themselves and speak, like Lalit Maheshwari. Please
Sir,
unmute yourself.
Yes, sir. I'm requesting that we have to find out what forces the IBBI to issue such draconian circular. Has it noticed some malpractices of our fellow IPs?
Okay, see, the basic reason was primarily right now only IBBI was taking disciplinary action. They want particularly for IPS to now come forward and take that lead on disciplinary proceedings. So, but they said that, look, one IPA may impose a fees of 2 lakhs, another may impose a 5 lakhs. So they wanted some kind of a consistency or a uniformity in the monetary penalties. So therefore, they have come out with a circular to ensure objectivity and uniformity. That is what the circular also says. So IBBI says, in the disciplinary matters, let the lead be taken by the IPS. IBBI wants to take a backseat on that. That's my feeling.
Ashish, can I add something to what you said?
Yeah, sir.
Yeah. So on the point what Ashish said, that this circular has come in line where IPA has to start take action, and all the three IPAs should levy same penalty for the similar type of contraventions. So I actually, after the circular came, I have tried to get in touch with the IPAs officials to get a feedback, and all the three feedbacks were similar. And all the three were of the view that only in case where guilty mind comes into play, this circular will get an effect. But the wordings of these circulars, what has been made. So when they amend the bylaws, probably they are also in consultation where how these things will be put in their bylaws. They may not be putting it verbatim as it has come in this circular. So that was one relief that I got when I tried to get in touch with them to understand how this is going to happen and what are the key things. So when, as Ashish ji rightly said at the start, that we need to have a patience and prepare ourselves in going ahead with the legal battle in case we are filing a representation or we are showing our issues to them. It has to be in a manner where we get the total feedback, not only one side feedback from us, our issues. We all as IPs are frustrated on various issues. So that frustration should not come out in our representation. The representation should come out with the legal points, the solutions, and the final outcome should be a win-win for the all. So practically, that is what the whole idea was there on this circular discussion today. Yeah, Ashish.
Okay. In fact, if we look at the 14 points, I think you can treat it as a checklist. So you now know what not to do. So it is absolutely clear what is not to be done. So anyhow, but of course, on the aspect of penalties, of course, we'll have to comment on that. So maybe I think Pratim, you can take a last question now, because I think we have already overrun the time now. Maybe one last comment from our friends.
Yes, sir. Hello, sir.
Yes, sir. Anyone can unmute and can say.
Sir, just
may I ask a small question? 1 minute.
Yeah, please.
So one small question. So there are some legal.
Sir, I think Mr. Arunamagam, I think let him speak first. So I think yeah. Then I think we can go to Mr. Haresh also. Yes. Yeah, or Mr. Haresh, you are unmuted. You can go ahead. Yeah.
Yeah, just I wanted to know, any professionals in India paying such huge penalties for small mistakes?
Harish, let's not take it that this penalty.
No.
Harish, let me take this question. Let's not take this penalties will be levied on us. As I said, that what will be the person to whom these penalties will be levied probably will be the person who to whom so-cause notice has been issued, who is unable to explain the issue, who is unable to show that he has exercised professional due diligence in complying his role, and thereafter the action penalty is to be sought. Probably at that time this penalty will come. Let us all pray that this concept of guilty mind or actually will calm down truly with this circular when the bylaws are adopted. But yes, whether it is there or not, it's a heavy penalty structure that has been put, no doubt about it. So that's where we are sitting today on Sunday and sitting and hearing each other out so that proper representation goes from all of us.
Okay, I think that's great. So maybe Mr. Arumugam, sir,
Yes,
I don't know whether I pronounced your name correctly or not. Please go ahead, sir.
Yes, sir. 2 days back, I think some parliament is now discussing and approving the personal guarantor and other laws. While the parliament is discussing the matters, whether IBB can issue a arbitrary circular, whether the IBBA is above the parliament, whether it does not require the parliament approval or government approval or cabinet approval, is it empowered to do whatever it likes? That is the only major legal question. I'm not a lawyer, so somebody who is best in law can able to analyze. Number 2, the amount of things can be reduced even if it is lawfully valid. The amount should be, because normally we are the low profile professionals. We charge only very small amount. It is okay if somebody is charging 1 crore or 50 lakhs each month or something like that. It's okay because you are asking only 50,000 rupees minimum. It is valid. But where the remuneration itself is 25,000 per month, then where is the question of 50,000 rupees minimum? So it's a very, there should be some point where at least high value customers, you may charge little higher, and the low, it should be avoided. And regarding the statistics, see, it is nothing but nowadays IBB is converting as a simple government department, simply collecting data and punishing them. The other functions are also there in IBBA. It is, as explained earlier, whatever cases under buff transaction has to be prosecuted. We don't know how many prosecution was carried out. So in addition to that, IPA only is not the stakeholders in this process. There are applicants are there, banks are involved, then a lot of other people are involved. You have to try to collect some amount also. The purpose is very clear. The government does not want to give any amount to the IBBA. It wants to self-sustain by the IBBA. That may be the reason why they are taking such a strategic step. But still, they should not only attack only the IP. That's my request.
Okay.
Thank you.
Okay, I think your points are well taken, sir. I will not comment right now because of the paucity of times, but I think you have made certain comments. I think they will be taken care of. So I think now I think we can wind up because it's pretty long now.
Yeah. Can I ask? Ashish, last one point that I put across to all, and would like to take this thing ahead as in the representing through IP Foundation for sure. And your suggestion, all foundations that are working, coming under one banner. Ashish, it will be one more association coming forth where all association can join for the common thing and take it ahead. I welcome the suggestion, and let's see how we can move that thing ahead. Only one small point on this circular. Like you have, I always in my sessions normally take this comparison, like with capital market. In capital market, there is a SEBI, we have IBBI. There are stock exchange, we have IPA. There are stock brokers, we are IPs who handle the things. But there is a set which is there where there are the issues against the SEBI goes, and we don't have anything against the IBBI here, tribunal for that. Because even if you go through the IPS, now when we are talking at the IPA level, when IPS registration or cancellation is there, they have an issue, they can go to NCLAT. But IPs, they have no source, but they has to go to the High Court if it has to be against the decision. So there probably a forum or a tribunal can be taken care, or the NCLT itself can take care of this, and we can look into it. Probably a suggestion.
Yeah, I think wonderful. I think those steps are to be taken. Yes, Pratim, I think we can now.
Yeah, now, yes, we are now at a time, we have extended 15 minutes, and too hot and too current a topic and too adventurous a topic to be concluded in a such a little time. And you have just initiated, sir, on all our behalf. So, and thanks all the participants for giving wonderful insights and all that. And definitely everyone, every panelist. Now I will hand over to Neha to give a formal vote of thanks before we conclude completely.
I will just intervene for a second. Please form a WhatsApp group of all these people who have participated, and at least one forum starts quickly. Start working on it.
शर्मा जी, WhatsApp group में सारे पूरे नहीं आएंगे, तो हरेश जी says के Telegram group, I think that's a good suggestion.
So let's form a group at least and get together on it.
Yeah, that will be done. Good suggestion, sir. Good suggestion. Yes.
Ashish ji, can I ask one question?
Yeah, Lalit ji, quickly.
Quickly, I think there is a over-regulation in the IBBI, over-regulation. Jabki for advocate, there is no such regulation in the Bar Council or Bar Association. I think we should initiate to not have so much over-regulation. When you are doing over-regulation, so ultimately there will be problem for everyone. Number one. Number two, I think I have raised the question why I given number of email to IPA and also to IBBI number of times. I'm just sharing with first time here. The person who don't have assignment since beginning or maybe no assignment till date. So in their case, the fees should be either reduced by 50% or 25%. I'm raising a new point. So because we are paying annual fees to IPA, we are paying once in 5 years fees to IBBI. Person who don't have any assignment, in their case, the fee should be reduced and the penalty should be linked with the amount fees I have received, not the maybe ad valorem amount.
ललित जी, अगर जिसके पास केस ही नहीं है तो उसको वो काम ही नहीं कर रहा तो पेनल्टी क्यों लगेगी उसके ऊपर?
नहीं, ठीक है, मैं बोल रहा हूँ, हमने कोई फॉर्म नंबर 2 फाइल किया, वो अगर रिपोर्ट नहीं किया, बाद में हमें फीस मिली है 5 रुपए, आपने बड़ी लगा दी 100 रुपया, मैं उसकी बात कर रहा हूँ मैं।
वो I think one of our friends already mentioned that doctrine of reasonableness and
हमें फीस मिली 5 रुपए, आपने फीस लगा पेनल्टी लगा दी 100 रुपया।
आशीष जी, वो फ्यूचर का सोच रहे, कोई नया सर्कुलर नहीं आ जाए उसके चलते।
Sir, can I ask one question?
So इनको बोलो कि दूसरा जो है असाइनमेंट जो है ना, असाइनमेंट शुड बी, दे शुड लिंक टॉक टू द आरबीआई कि असाइनमेंट जो है शुड बी गिवन टू ईच एंड एवरीवन इन एटलीस्ट वन असाइनमेंट फॉर एवरी आईपी एटलीस्ट वंस इन अ ईयर या वंस इन 2 years. ऐसा कोई सिस्टम होना चाहिए जो है।
Yeah.
Okay, so it's I think now we let us conclude. It will be a never-ending thing. It has been initiated, and we would request other the panelists and the other participants also. We will be meeting together in other forum. It has just initiated, and definitely we will have much more voices on for a genuine reason. So Neha, I think you can give a formal vote of thanks to the panelists.
Others can send suggestions by mail, sir. You can announce that also.
Yeah, that is already announced. The email ID has been written in the chat box. I'll write it again. In the meantime, Neha, you can take it over.
Yes, sir. I would like to thank all panelists for their enriching discussion on a burning topic affecting all the IPs. The participants made useful comments and their inputs will help in making a forceful representation on behalf of the IPs. On behalf of Transition, I thank each one of you for sparing your time. We look forward to your continued support. Thank you. Good night, everyone. Stay safe, stay healthy.
Thank you. Thanks.